The grand finale as far as introductions? Got it down pat?
Sure.
Okay. Remember, you're gonna be ways away, so let's go ahead and you may be seated. Please introduce yourselves.
I'm James Osgood.
Hi, I'm Annie Helian.
I'm Max Demers.
And I'm Delaney Ruff. Our unit coach is Mr. Oakes, and our classroom teacher is Mr. Clark.
Okay, and for this unit, we've selected question 1, which reads as follows. What are the basic purposes of the 14th Amendment? How are questions left unresolved that the Philadelphia Convention addressed in the 14th Amendment? How are the due process and equal protection clauses of the 14th Amendment related to principles of limited government? And when you're ready, you may begin.
During the bicentennial celebration of the Constitution, Justice Thurgood Marshall said, "While the Union survived the Civil War, the Constitution did not. In its place arose a new, more promising basis for equality and justice, the 14th Amendment. From the ashes of the Civil War arose this 14th Amendment." Authored by Ohio Congressman John Bingham, the 14th Amendment was ratified in response to the many problems apparent during Reconstruction, with basic purposes such as establishing a national definition of citizenship in order to provide classification for the newly freed slaves.
Additionally, the 14th Amendment protects the privileges and immunities of all citizens, including due process and equal protection of law to all persons by enhancing the natural rights philosophy outlined in the Declaration of Independence, through ensuring life, liberty, and the pursuit of happiness. The amendment also created restrictions against Southern disenfranchisement, punished Confederate officials, and negated the debt of slave owners while giving Congress the power to enforce the amendment by appropriate legislation.
The importance of putting federal power ahead of states' rights was founded in the failure of the Articles of Confederation and the necessity of the Philadelphia Convention. The 14th Amendment in part answered some of the questions left unresolved at the Philadelphia Convention, but more importantly, it set off a chain reaction by promising a basis for justice and equality, stated by Justice Marshall. Questions about citizenship, voting, representation, and a significant check against state power were left unresolved to appease many delegates.
In Federalist 54, James Madison affirmed that slaves are considered as property, not as persons, and resolved to count them as 3/5 of a person. The 14th Amendment not only gave the freed slaves jus soli citizenship, but also counted them as a whole person for purposes of the census. The Privileges or Immunities Clause of the 14th was designed to protect the applications of the Bill of Rights towards the states and overturn the 1833 Barron v. Baltimore decision. However, the 1873 slaughterhouse cases effectively eliminated this clause, postponing incorporation until 1925. In Gitlow v. New York, the Supreme Court ruled that the First Amendment limited all states according to the Due Process Clause of the 14th Amendment, reversing the Barron decision and beginning the selective incorporation of the Bill of Rights to limit the states.
The principles of limited government are reflected in the Due Process Clause, which limits states from passing legislation that violates both procedural and substantive due process. Procedural due process requires that states act in a certain way before they can take a person's life, liberty, or property. It is this idea that allowed for the doctrine of incorporation to prevail, as seen in the 1932 case, Powell v. Alabama, which incorporated the right to fair trial, prohibiting states from arbitrarily denying any person their procedural due process. However, incorporation is not absolute.
In the 1937 case Palco v. Connecticut, the Supreme Court stated that the Double Jeopardy Clause of the Fifth Amendment did not apply to the states because states not only have a compelling state interest to uphold their own due process in criminal and statutory cases. Substantive due process protects certain fundamental rights, such as privacy or marriage, that cannot be infringed upon by the government without a compelling state interest.
The Equal Protection Clause also upholds the ideals of limited government by prohibiting states from denying all persons equal protection under the law. States often establish laws that create classifications, such as Nevada Revised Statute 433, which provides definitions for mental health. In the 2001 case, PGA Tour versus Martin, the court used rational basis to rule in favor of Casey Martin and allow him to use his golf cart because of his circulatory disability.
Cases of race would fall under strict scrutiny and gender would fall under intermediate scrutiny. As the issue of same-sex marriage makes its way to the Supreme Court, the question of which level of scrutiny the court will use will become important to legal scholars as the clause continues to progress. Equal protection under the law is one of the most important safeties to fundamental and inalienable rights such as life, liberty, and the pursuit of happiness. Thank you.
Four. Okay. Oh, I waited the whole semester to ask this question.
Oh gosh.
Is the Civil War really over, or did Lee just surrender to Grant?
The Civil War and the issues of slavery and things like that were over once the Reformation amendments were approved. But the Civil War in the idea of a balance between state and executive federal power is really not over. Even though Lee surrendered to Grant at Appomattox, thank you, is really the lasting results of the Civil War that are these issues between the precarious balance of state and federal power.
Even today, we still see problems with cessation. In the White House, there are petitions that if they get enough signatures, they can be brought to the attention of the White House. And even as recently as under President Obama, Texas, Nevada, and Montana have attempted to bring these petitions up for debate about whether they should secede or split into different states.
Go for it.
Okay, one of the provisions of the 14th Amendment is the enforcement clause, or the enforcement provision. Has Congress gone too far in the use of the enforcement provision? Why or why not?
Congress has not gone too far in their use of the enforcement provision. In fact, the enforcement provision has been used to achieve several acts of Congress, such as the Civil Rights Act of 1964, which basically furthered the ideals outlined in the 14th Amendment that all people should be equal no matter of race.
I completely agree with what James just stated. The enforcement clause of the 14th Amendment really provides this power for Congress to even further pursue the ideals found in the Declaration of Independence and within the Constitution of a natural rights philosophy that really protects people and provides that equality that we really need. The enforcement clause is completely necessary, and everything Congress has done is completely necessary because it's the protection of equality that Congress really has to use the enforcement clause for.
How does the Supreme Court define privacy as constitutional?
Privacy is not found anywhere in the Constitution, but it has been defined in several Supreme Court cases as being apparent in the penumbras of several other constitutional protections found in the 5th, 9th, and 14th Amendments. These court cases have upheld privacy as a fundamental right.
In Griswold v. Connecticut, the Supreme Court states that the right of privacy is implied through these amendments in the case where a family could not be restricted to information about abortions in Connecticut.
How do you think the United States might be different if the Supreme Court had not applied the process of incorporation to the Due Process Clause?
Without incorporation, our Bill of Rights really doesn't apply to us. Without incorporation in the application of the Bill of Rights to states, we aren't protected. Say, for example, if I'm speaking out at a protest, or if someone is using their Second Amendment right of defending themselves, we aren't protected with our Bill of Rights. If we didn't have incorporation, the Bill of Rights really is debunked because unless it's federal holdings, we don't have those protections.
I agree with Annie, and incorporation has also given us numerous instances where the states are limited in what they can do to us. For example, in McDonald v. Chicago, the Supreme Court ruled that the city of Chicago cannot prevent citizens from using handguns.
Also, our landscape would be much different if there was no incorporation, because the First Amendment might not have been incorporated, and the First Amendment has been instrumental in achieving other amendments, most notably the voting amendments, because these minorities who were denied the right to vote were using their First Amendment rights to assemble and speak out and promote their cause.
How have the court's interpretations of the Equal Protection Clause changed?
Could you repeat that, please?
How have the court's interpretations of the Equal Protection Clause changed?
In some ways, the court's interpretation of the Equal Protection Clause can be seen through the difference in Supreme Court rulings from past times to now. Equal protection, really, when the 14th Amendment was created as a Reformation amendment, was thought of as more of a protecting African Americans, protecting former slaves. Now the Equal Protection Clause is really seen as this universal clause for the United States to protect all citizens under the law.
For example, the Equal Protection Clause in modern examples has been used in Title IX and affirmative action cases in which they might not be looking specifically at racial minorities as they were when the clause was created.
For example, in Groots v. Bollinger, the University of Michigan undergraduate school, their process of assigning points based on race was deemed unconstitutional because it it defined a certain favor towards particular races.
And
Go ahead,
even
Mom.
more modern, it has been applied to different sexualities since Loving v. Virginia, when homosexual relations became a part of privacy, not of public. The Equal Protection Clause has been used to protect them from the same discrimination that races would be expecting because they are minorities in how they identify themselves.
Okay,
We're
Tyler?
at the stop, yeah, we're at the stop.
Totally could have brought up
We probably gotta make this real quick.
Yeah.
So, you know what? I have never, ever heard an answer to my question about the Civil War and Lee surrendering to Grant than the two answers that you guys gave. Those are probably the best answers I have ever gotten on that question, I gotta tell you right now, because I've asked that question for about the last 4 or 5 years, and you should hear some of the stuff I got. And that was probably the best answers that I have ever gotten on that question. And it's obvious that you're not stressed tonight as you were the other night, because
Perfect. Well, I didn't drive myself here.
she was a mess the last time, and this time, I thought, you know, there was a couple of hesitations there on some of the questions that Mr. Martindale might have asked, but other than that, I thought you did a good job as far as answering all the questions.
Billy, open your testimony. Okay, in your opening, in your first paragraph, you read to a point and then you say, you essentially introduce the 14th Amendment, okay? What I'd like you to do is, you were reading up to a point, and then when you said the 14th Amendment, it went off. It's like you got to the 14th Amendment, you go, the 14th Amendment. What I'd like to hear you say is, you know, hesitate and say, the 14th Amendment. You know, emphasize it. Because you've introduced it,
Out of the ashes of the Civil
I mean,
War came something like
the
that.
14th Amendment. Yes.
That's what it was, right?
Okay, you see what I'm saying there? So just emphasize that. I gotta tell you guys, you had, in your testimony, you had 2 references to someone or a quote or something like that. You had 4 references to the Constitution. You had 6 references to case law. In your cross-ex, you had 3 references to someone or something, 2 to constitutional, and 4 references to case law. I've never seen that much reference to case law. It was outstanding.
This one's like really case heavy.
Yeah,
It's
this
not
amendment
heavy.
is all,
You gotta believe me, you got a whole bunch of attorneys gonna sit on the other side.
Yeah.
Just
like-
better know what that case law is, okay? Don't just throw it out. Better know what it is if somebody goes, hey, so tell me about it, okay? But I thought your balance was great. Good confidence, great teamwork across the way. I was beginning to wonder whether you were gonna play the sandbox nicely here, but then you picked it up and did a nice job. Okay, so get yourself involved earlier, so people aren't wondering about you. But outside of that, just keep refining, guys. Just keep working.
Thank you.
All right,
Did someone turn the camera off?
let's see this thing. Let me give you just an idea of what we mean.